Hello, everyone. If you're new here to this channel, I'm Harlow, creator of the HR Insider. And on this channel, what I do is I talk about real stories by sharing real legal cases that also talk about conflict at work and what actually happens when an employee brings a complaint to HR or to leadership. So, thank you for being here. And if you're watching the replay later, feel free to leave me a comment. I do read all of the comments and I try to respond to as many of them as I can. So I have to say that I am genuinely impressed by this audience. And one of the reasons I am so impressed is because the channel is not about, lifestyle, it's not about popular topics. And what we do talk about is they're not light topics, they're very challenging topics. And they're complicated. We talk about court decisions, investigations, retaliation, just a lot of gray areas that I think come with employment law. And what impresses me most is that so many of you are really thinking through the issues that we talk about on the channel carefully. You are asking really thoughtful questions. And as you're watching the cases and taking the training courses, you are re- you're not only just paying attention to what you're hearing, what you're seeing, you're also trying to understand how these issues actually work in real life in the workplace. And so, what that tells me is that there is a real need for this type of content. And I think that it takes complicated issues at work and it makes them relatable through real cases and the facts that I share with you through those real cases and the decisions that affect an employee's life. And that's also why I want to encourage you to subscribe to the channel. The information we cover, it may not apply to something you're dealing with today, but it could help you later. And you would be surprised by how quickly an issue at work you would be surprised by how quickly an issue at work can surface. And when it does, I think it really helps to already understand what employers look at and what courts consider. You want to have a better understanding about what evidence you need to collect. And that is all important. And it can make a big difference in a claim. So, subscribing really helps the channel grow. Obviously, it tells YouTube that this content is valuable and it helps more people find it. And so that is what makes it possible for me to continue creating and publishing videos about these cases and offering the training courses and the practical resources that are on the channel. So if this channel has helped you understand how to deal with conflict at work, or maybe you're learning more with every new video that I publish. Maybe this is information that might be able to help you in the future as well. So please subscribe. It's one of the simplest ways that you can help me continue making this content. All right. So, a viewer recently asked me a really smart question, which is why do some employers seem to investigate one complaint seriously, but handle another complaint like they're just protecting themselves? Why does one employee's complaint get a full blown investigation, including witness interviews, documentation, and follow up, while another employee's complaint gets ignored? Or delayed or handled like the employer has already decided the outcome. And the reason I called it a smart question is because when you're talking about employment cases, the what is happening when a complaint is made, um, the process that is unfolding through either the investigation or the witness statements or whatever the process is following that complaint. The investigation itself can very easily become such a critical part of the evidence at trial if something does move forward into legal proceedings. And so sometimes an investigation will show that an employer responded in a way that was reasonable, in a way that was looking for information in an objective way. And sometimes it will show that the employee's complaint was taken seriously as well. But how that investigation is handled and what the employer does, it really points to whether or not they were trying to find the truth or if the employer was trying to protect itself or protect a manager or just working on building a defense against the claim. And if you will look at some of the cases that we're going to talk about tonight that are on the channel, you can see how that definitely became an issue. So, tonight, I want to walk you through some real stories where employees raised complaints. There were investigations that took place, and that investigation became a central part of the claim that the employee brought in court later. And I want to show and point to the difference between a bad investigation that can create legal risk for the employer and an investigation that it might feel disappointing to the employee, but it doesn't necessarily prove that there is illegal conduct or that the employee violated the law. And from what I've seen, many employees do not necessarily have a good or positive view about investigations at work. And some of you may feel that way too. So if you hear the phrase HR investigation, do you think of a real search for the truth? Or do you think of damage control? If you don't mind sharing your thoughts about that in the chat, because that's a question that is really at the center of tonight's live. And let me see if there are some comments here. I am Batman says, I love this channel. Thank you so much for being here. I am Batman. Appreciate your support so much. And he says, I have a question. If you have multiple claims, like you have been an ADA, if you have a question, okay. Okay, so he says here, I have a question. If you have multiple clear claims, like you have both an ADA claim and a workers' comp claim, retaliation, and FMLA violation, does the value go up or does it stay the same? Does an HR cover up usually increase the monetary value of a claim against a company? Okay, so let's take those questions one at a time. I think the first question being if you have multiple claims. If you look at the cases that I've shared on the channel, the one thing you're going to see that's a common thread is every claim that is brought to court usually has multiple claims that are being alleged by the employee. So, very rarely is there just one claim. Usually there's hostile work environment, harassment, retaliation. Retaliation is almost always looped in there. And so some of those claims will be stronger than others. Some of those claims, if you look at some of the cases on the channel, the judges threw out the weaker claims and allowed some of the stronger claims to move forward. So the value and how the claim is going to be assessed in terms of whether or not it increases the value because you have multiple claims is really going to depend on the depth and the weight of the claim that you're bringing. If you're bringing a claim that has substantial evidence, then that claim can be heard. If you're bringing a claim that has very light or weak evidence, that claim might be thrown out. But ordinarily, you're going to find in the cases that I've covered that lawyers are going to bring multiple claims to the court. They're not going to bring just one. So, from that perspective, it definitely gives you more opportunity for your claim to be heard. But whether or not it increases the value of the claim really depends on the weight of the evidence and how much you can substantiate the allegations that are being made. Okay, the next question you have here, I am Batman, is let's see, does an HR cover up usually increase the monetary value of a claim against a company? And what I would say there is the answer if you look at some of the cases on the channel, one of the videos that I always talk a lot about is the Annie Shaparian case. It is definitely one of my favorites because she made multiple complaints to her employer. I think by the time she finally left her employer, there were over a dozen complaints. And the cover up in that case was that they attempted to point to what she had done wrong. Don't want to get into a lot of details about that case, but if you go back and look at it, the word cover up certainly comes to mind because Annie was being told that what she did resulted in the outcome of her employment being terminated. But we know, of course, that's not what was proven in court. So it was the court decided in that case that because of the employer's eh, ongoing and persistent bad conduct towards the employee, they included punitive damages. So if it rises to the level of misconduct, ongoing misconduct, it certainly could contribute to a higher penalty that the employer incurs. And in that case, Annie was able to prove that the employer had, in fact, made it difficult for her to move on after she left that employer. So, in that case, a cover up did result in a greater payout to the employee. So, I would encourage you to go back and look at that case and listen to why the court decided that she needed to be awarded punitive damages in that case. All right. So, moving on, as I mentioned earlier, uh, I don't see any other comments here, so I'm going to move on. Um, if you've ever wondered why some investigations feel real, if you've ever been a party to an investigation, and you've also seen others that might feel like a cover up, I encourage you to stay with me because we are going to look at what happens when an HR investigation starts to look like that, starts to look like a cover up, and what counts as something that a court would pay attention to if it goes, if a claim is litigated. And I also want to talk with you a little bit about the case that I'm going to cover this Sunday because it fits almost perfectly with what we're discussing tonight. So stay tuned for that preview. And as always, I will try to get to as many of your questions from the chat as I can. Now, before we get started, I want to mention that the information I share on this channel, it's for educational and informational purposes only. It is not legal advice. If you're dealing with a specific issue at work, you may want to speak with a qualified attorney or someone who can review your situation and give you guidance. Okay? And I also want to acknowledge the seriousness of the topics we're discussing tonight because we are going to talk through the cases in a very practical, teaching focused way. But I don't want to minimize that what we're discussing are issues that have a serious impact on people's lives. When you're talking about things like harassment, retaliation, complaints that people are making, but they're being ignored, unfair investigations, that is compromising. It's easy for it to compromise a person's sense of safety at work. And when I discuss and review these cases with you in such a structured way, that's not because the issues I think they're not important or they're small. And it certainly isn't because the human impact doesn't matter. It does matter. That's one of the reasons I started this channel. The goal of this channel is to help people understand these situations and how they're evaluated, what facts really matter, and look at what evidence a court might review if a claim is brought is litigated. So the teaching format that I use, it's not a reflection of the seriousness, the severity of the experience that people have. This is just a way that I try to make really complicated issues understandable for you. All right. So, the first employee I want to talk through tonight is a case I covered on the channel called The Investigation That Sparked a Discrimination Lawsuit. And the thumbnail on that video is HR's Costly Investigation Failure. And this is the Charmaine McGuffy case. Hold on just a moment. My apologies. Okay. So this is the Charmaine McGuffy case. And this was a investigation that it was unfair. Uh, the investigation was unfair because it was treated differently in the scale of it. It was a massive investigation. The intensity of the investigation, how long it lasted, and the scope of the investigation. They really it was a very broad investigation that happened over a number of years, especially when it was compared to other investigations. And Charmaine was an employee where she was going through some things at work. She observed some things that she felt were not right. She was in leadership. And so she decided to voice concerns about it. And she felt like she had a safe space to do that, and she felt like it was the right thing to do. And because what came out in court is because she took that step, this investigation was launched, and it essentially was they call it a witch hunt, right? That's what they say about HR investigations, that it was a witch hunt to get her on something that she had done wrong. And so the court didn't care that the employee felt the investigation was unfair, but she was able to show that it wasn't handled the way other investigations were handled. So, as I said, it was so broad, it lasted for so many years. In comparison, I think it was hundreds of pages, whereas other investigations were 5 pages. So it was substantial. It was definitely pointing to an inconsistency. So sometimes the investigation itself can become the evidence, not necessarily, what the outcome was, but the investigation being done. The investigation was done as a result of a complaint that was filed against Charmaine. So it was very political, but she raised a complaint at work. Like I said, she was in leadership, and someone else filed a complaint against her. And so that's when it became like I said, a witch hunt to identify what Charmaine had done wrong. But in this case, really, what the court looked at was the employee, Charmaine McGuffy. She was investigated in a way that was very aggressive, and it was different from how other complaints were handled. So, this speaks to the motivation of the employer. Why were they taking such a strong position with her? If the investigation goes beyond the complaint and it digs through, like it did in this case, years and years of an employee's career, that is very burdensome and more burdensome than a standard investigation would be. So the court really began looking at, what was this investigation really about? Was it about the complaint, or was the employer looking for a reason to justify the outcome? And that's exactly why, when she took her case to court, she was able to demonstrate retaliation, because they had such a broad investigation that they weren't able to defend it as a truth seeking exercise. And it just looked as though she was being retaliated against because she brought legitimate concerns to her employer. So, this is one of the cases. If you have not seen it on the channel, I encourage you to go and look at that video called The Investigation That Sparked a Discrimination Lawsuit, because it really does show you how an investigation can be used as a weapon. It can be used because the outcome of that was she lost her job. Essentially, it's a little bit more complicated than that, but essentially that's what happened. She lost her job, and she definitely was being pushed out through that investigation. Okay, so I'm just checking the chat here. Someone says, what happened when he conducted a selective investigation, even? What happened when he conducted a selected investigation? Well, in this case, what happened was Charmaine lost her job. She was no longer employed, and they had to defend it. So, where justice took place was in the courtroom. The employer was not the employer was responsible for the investigation itself. It took years. And, if you've ever that's one thing, if you've ever been in an investigation, either you've been a party to one where you've been a witness, or you yourself have raised a complaint, or someone has raised a complaint, made an allegation against you, one thing for certain, that is not an easy space to be in. And you can understand why. You've got this dark cloud hanging over your head. You're waiting on this investigation to be over. And keep in mind that investigations are usually not very quick. Most of the time, they take time to finish out. You're talking to people, you may have people travel, you may have to review evidence that different witnesses have. Sometimes they can become very complicated. But in Charmaine's case, the investigation took place over years. So she was subjected to that kind of dark cloud. I'm going to describe it that way, where she had something in the back of her mind that she knew could impact her life for a number of years. And that was problematic for the employer in that case. So the employer did not correct their own behavior, if that's what you're asking. Okay, so now I want to talk to you about Nicole Graham, because Nicole Graham, this is another story that I've covered on the case. And the video is called "Who Does HR Really Protect When Harassment Complaints Are Ignored?" And the story is about Nicole Graham, who was hired as a territory sales manager. And what she alleged is that she was attacked at work, sexually harassed at work, and then she filed a complaint about it. And so that's the Graham story. And the employer in this case didn't conduct a fake investigation. That wasn't what was happening. It wasn't a procedural thing. We're just going to check the box. It's important to remember that not every bad investigation is actually a cover up. Sometimes it's the structure of the process. Sometimes the complaint system, the procedures that an employer is supposed to follow, they haven't done that, and the report, it may not get to the right person. Maybe the person who's complaining is talking to others, but they're not talking to who they need to talk to in order to see some type of positive outcome, the outcome that they would like to see. And that's what happened with Graham. She made allegations about sexual assault, but unfortunately, she didn't make the allegations to the people that could have made a difference. By the time she made it originally with leadership, and by the time it made its way to HR or to other people in the company who could take action based on her allegations, a significant amount of time had passed. And what happened to her is, as that time was passing, she continued to be exposed to the person that she accused of harassing her. And what that tells you, did the case say that? No. But what that communicates to me is that management, the people that she did tell about, the people that she did share her concerns with, those people who were in management, they minimized the issue. And so when it finally made its way to HR and to other key leaders, corrective action in that case, it was actually taken, but it was taken too late. And it was taken for an extended period of time following that complaint. So an employer can create legal risk just by refusing to investigate, uh, but also by allowing an employee to remain in the same type of environment they were in while that process was being dragged on, while it was being assessed. What do we do? How do we handle this? There's another case that I covered on the channel about fossil watches, fossil, not watches, but just fossil. Okay. And in that case, you will see that an employee, she made a complaint similar to what Graham did. She made a complaint about sexual harassment, but she made it after she left. And so, because she never filed her complaint, she never made her employer aware of what she was experiencing. The Texas Supreme Court said, you didn't, there's no evidence that you were subjected to harassment, because the window of time between when you left the organization and when you said you complained about this complaint, that window of time is very, very narrow. So once her employer, in that case, once her employer found out about it, even though she was gone, they fired the person who harassed her. They conducted a full investigation, and they did find evidence that the person that she accused of harassing her was, in fact, not just harassing her, but harassing other employees as well. Go back and take a look at that one. That's an interesting case. But in contrast to Graham, which is the one we're talking about tonight, Graham was a sales manager, and she was someone who did make the complaint known while she was employed. And so there wasn't a cover up. What happened was, there was a poor process. There was a delay. There was a failure to protect Graham while the issue was pending, while they were trying to figure out what to do. She told leadership, but it didn't make its way to HR the way that it should have in a timely manner. And so that's an example of a bad investigation, even though the employer didn't intend for the investigation to be bad. You have people who have an obligation to take action, and sometimes they don't. I know a lot of people will say, for example, don't complain. Don't say anything. Just leave. And I'm not here to tell you what you should or should not do. But what I do want to make you aware of is if you don't complain and then you decide to pursue it legally, that's what happened with the employee in the fossil case. She decided to pursue it after she left. She had some evidence. She did. She had evidence to support her claim when she went to court. But the problem was she didn't make the employer aware that that was happening. So because she did not notify them, they can't act based on what they uh, didn't know. Now, in court, they raised the idea, the concept of an organization looking through its corporate eye because an employer has a duty to make sure that your environment is safe, that you're comfortable, that you're not being harassed, that you're not being compromised in any way. And so that was one of the arguments that was made against Fossil that they should have known. And I don't get into all of that related to that case. Go back and look at it if you want to know more about what happened there. But the point is, reporting and reporting to the right people does make a difference in an investigation. Sometimes it's not that the employer intentionally wanted to conduct a poor investigation, but sometimes there's a delay that is just because of the process not being the way that it should be handled procedurally, okay? So that's the second example. So the first example was Charmaine McGuffy, where her investigation was turned into a weapon that was used against her to affect or impact her employment relationship with her employer. The second one that we just covered is about Graham, who was a sales manager at a company, and she made a complaint, voiced concerns. There was an investigation, but there was a delay. The next case we're going to talk about, and this is a really important case, it's Baldwin v. Blue Cross. And I have covered this particular case so many times on lives. It's one of my favorite cases on the channel. The video title is She Had 5 pages of evidence, but it still was not enough. And the reason I love this case so much is because this investigations aren't always about a bad investigation equals liability. I think it's important to know that an employee can document, they can complain, they can identify witnesses, and unfortunately, what they have still doesn't meet the legal threshold that's required in order for in order for that complaint to be legitimized in court. So when you think about an investigation, it doesn't always mean the employee gets the outcome they want. And that's something else. If you look at any of the investigation videos in the investigation playlist, you will see that sometimes the outcome is not what the employee wanted, but there are cases where the outcome is reasonable. And that's what happened with Susan Baldwin because HR did investigate. They did interview. They did go through the process of reviewing evidence, but it did not establish that there was a legally, like a hostile work environment that was portrayed through the evidence. Now, if there was a violation of policy, that's an argument that is different. But in this case, we're talking about what happened in the courtroom. And the court said that what happened to Susan was not severe or pervasive enough. And just remember when you're talking about investigations and you're talking about your work environment, there are three things that are always going to be at play for an employee who's bringing a complaint to the employer. The first thing is your culture. What type of culture does the employer want to promote? There are some employers that are fine with a bad culture. They may say they don't like it, but they don't really do anything to change it to make it better. So that's the first thing that's going to impact your complaint. You need to have an eye and an understanding on the culture. Does HR take complaints seriously? The second thing is if there's a policy violation. If you have someone who is inappropriate at work once, that is enough for a policy violation. I'll give you an example. If I'm a person in leadership and I go and I have a relationship with a subordinate, well, that relationship with my subordinate might be against company policy because that person works and reports into me. Now I have a relationship that could compromise how my other subordinates feel about my decision making, about my objectivity, about my ability to be an effective leader, that it might be compromised. So that one time relationship could be a violation of policy. It could be a violation of the subordinates policy. It could be a violation of other employees how they feel, like a violation of what they feel is right, and so there might be a concern there. That's a policy violation, right? Okay, so the third thing is whether or not there is a legal issue and whether or not the conduct has met the threshold that's required in order for a complaint to be determined by a court as something that is a violation of the law. And so those are the things that are important for you to think through and consider as you try to figure out where the line is and how an investigation might work when you might think to yourself, well, I complained, but nothing happened. They ignored me. That can be true. That can happen. But sometimes HR has investigated the complaint and they've determined that there's not enough. There's not enough corroboration. There's not enough to substantiate a policy violation or that there has been enough that would terminate the person or hold the person accountable that you are making the allegation about. Okay. Sometimes, and I hear this often where people will say, well, HR investigated, but it didn't support the outcome that I wanted. And that's a mature way to look at it if you know that the investigation was valid. But sometimes it's very difficult to be objective when you're the person who is experiencing the the bad behavior. If you're the person who's experiencing the bad behavior, sometimes you don't care that HR doesn't have a policy violation or that it doesn't reach the legal standard. You just want a different outcome. And I certainly understand that, but you have to look at the reality. Every person involved in the investigation has rights, even the person who is accused of the bad behavior. So let's move on. I want to talk about Culp and Peters versus Remington Montrose Golf Club. This title of this video is called Fake Investigations: How Employers Pretend to Investigate Complaints. And I wanted to include this story in tonight's live because it really addresses something that I think people struggle with which is what happens when I make a complaint and HR flat out doesn't believe me. They just don't believe what it is that I have to say. The issue with Culp and Peters is exactly that. They had made a complaint against an employee that had bad behavior, inappropriate behavior at work. And for whatever reason, the employer in that case, they did have an attorney that they were working with. But they decided that despite the attorney's recommendation to them, they decided that they did not want to conduct a full investigation. Culp and Peters both felt that their concerns were being dismissed and discounting their complaints very early in the process. Even the way the investigation was conducted was a problem very early on. And sometimes that's one of the ways that you can tell that the investigation is not objective is that you're not being treated as someone that is has a legitimate complaint. You're being treated as someone that, "Go away, you're dismissed, we don't care about you," or "We're not gonna respond to you." And in that case with Culp and Peters, the investigation was so narrow because, again, they had already made the decision that the employees, Culp and Peters, were not being honest about their accusations. And so when it went to court, because they had made determinations about Culp and Peters, they decided that they were not credible. That's what happened. They said, "We don't believe that you're being honest about what you experienced." And they actually said that to them. They said that in some way. I don't know if they said that to them directly, but they wrote it in their notes. Somehow it made it to trial. And so in that case, the court was looking at whether or not what did they use to make the decision about Culp and Peters? How did they determine that they were not credible? And there wasn't enough evidence to substantiate why. For example, if an employee has been lying about their time card, if an employee has been written up several times for uh, lying about something that is later found out to be the truth, you know, you would have evidence and rationale to question the credibility of the employee who's bringing the complaint. Now, that doesn't mean that they're not bringing a legitimate complaint. Don't misunderstand me. A person can lie in the past and still be honest about an inappropriate experience that they've had at work. I think the saying goes that even a broken clock is right at least once a day. So you can't completely discount someone because they haven't been truthful in the past. But in this case, the employer didn't have that. They had nothing to legitimize their lack of credibility they had placed on these two employees. So the court said, was it just a convenient reason for them to avoid taking the complaint seriously? And as I read through the case, that was exactly what I thought because the person who they made the complaint about was someone who was very um the person they made the complaint about was someone who was very valued at that company. And because that person was very valued at that company, they didn't want to see and that's what I surmised from reading the case. And did the case say that? No. But I think I am probably on the right track with that because the court actually asked that question. Was it a convenient reason to avoid taking the complaint seriously by saying the people who brought the complaint simply were not credible? And so You're looking at some opposites here. You're looking at Baldwin, who had a very legitimate reason, a legitimate claim. She was taken seriously. Baldwin case is somewhat heartbreaking because she had dealt with some pretty tough circumstances at work for a really long period of time, and I think by the time they presented Baldwin with options, she'd had it. She was just done. She's like, I'm not dealing with this anymore. I'm out of here." And so, but in this case with Culp and Peters, they didn't take them seriously at all. They basically dismiss them, and part of the rationale, I believe, is that they wanted to retain the person who they were accusing. They didn't want anything to jeopardize that relationship that they had with that employee. Okay, so, uh, again, in Baldwin, the investigation was adequate, but the evidence didn't carry the legal claim that Baldwin made. But in Culp Peters, the concern was the employer's credibility, how they assessed the Culp and Peters' credibility, and that caused the investigation to be more performative, to not be real. And it needs to have a hint of realness. It needs to, at the very least, demonstrate that it's thorough. And in that case, it was not. Okay. So let me just check the chat for a moment here. What happened when HR conducted a selective investigation when two employees committed similar misconduct? Female employee keep her job, male employee got terminated. Ooh, yeah. So what happens in HR investigations is and a lot of times what is happening with an investigation that's being done is not going to come out until it goes to be litigated, or you're doing discovery, or there's an EEOC complaint. So if one person is allowed to remain and the other person is not, the assumption and the reasonable assumption is that's not right. They should both face the same fate because they were both a party to whatever the issue is. But oftentimes there are nuances, not always, but sometimes there are nuanced things or things that are more substantive in one employee's file. What I mean by that is a prior history, other issues that have come up. It could have been 5 years ago, it could have been 10 years ago, it could have been 2 years ago, but something else that makes it reasonable to terminate one employee and not terminate the other. But, HR can't publicize the reason why. And what happens a lot of times is one employee will say, "Look at how they treated me. They treated me so horribly wrong. I lost my job, but the other person didn't." But they're not gonna disclose to you that they were written up a few years ago, or they were given a final warning 3 years prior about a similar infraction, or they were on a PIP and it was, what I mean is that there could be other circumstances. Sometimes there are. Sometimes, as you will see in the cases we're talking about tonight, it's about what the employer wants to do. If they have their mind made up about, in Culp Peters, they decided that Culp and Peters were not credible. And so they already had their mind made up. But in Baldwin v. Blue Cross, you see there how they did conduct a investigation and it was very thorough, but the outcome still was not what Baldwin wanted to see. The person she accused of harassment was not terminated. And so HR is not going to publicize all of this that I'm talking about. I only know it because it went to trial. If it hadn't gone to trial, if I were an employee who was looking at what was happening to Baldwin and she was confiding in me about her experience, I would have sympathy, and I do have sympathy with her actually, with what she experienced. But unfortunately, there was not enough to substantiate that the accused had violated policy and reached the level of the legal threshold that's required to demonstrate a violation of the law. So, you know, unless you have the details, and what do I mean by that? You need both employees' files. You need to know both employees intimately. You need to make sure that everything they've disclosed to you is accurate, because a lot of times you're not going to be aware of that. Um, so it's difficult for you to make a judgment if you don't have all those details. Okay, so I see another comment in the chat. I'm sorry, I wasn't able to join you until just now. I'd asked the question earlier about whether there's a serious allegation of misconduct. If the investigation decides that the allegation is true, does that make their legal defense more difficult? Sorry if you already covered this. Hello, thank you. I was actually going to cover it. I was hoping you would join because I did see your comment. And I see you made another comment here. The reason I ask is because I'm so confused by some of the behavior I've seen at a large and wealthy employer with many very high compensated employees. They have a huge legal department with in house counsel of many different specialties and a dedicated trained HR team specifically for investigating complaints, and they seem to conduct investigations in good faith sometimes. But there are other examples where the evidence is very clear, the liability is large, and they are very blatant about not conducting the investigation in good faith and then firing the person who made the complaint, with the justification for firing being very obvious pretext. I don't understand why they would voluntarily take on so much liability for themselves or seemingly for no reason. Okay, so what you're asking is a multi layered question. So, and it's a great question. And so I want to talk about it for a minute. If HR admits that an employee did something wrong, okay, I think the answer to that admission and if it's okay or not, it's complicated. It's not black and white. So I'm going to try to break this down because a good investigation, all right, what it does is it actually helps the employer defend itself. Why? Well, I've given you a couple of examples tonight. When I talk with you about Baldwin v. Blue Cross, they conducted a fair, objective, and thorough investigation. So when they went to court, one of the reasons why they were able to prevail in that case is they demonstrated that they took Baldwin's complaint seriously and they demonstrated that they conducted a very thorough and complete investigation. And so that helped them in court. Now, if you have another example of an employee where an investigation was taken, I think if you look at Culp v. Peters is a good example because that investigation was done, it was not thorough, and they were trying to protect someone. The employer was actually and it's a different employer, which I know is different than your question, so just hang with me for a minute. Those 2 contrasts show you that if it's thorough, the company has protection. If it lacks objectivity and it lacks a complete investigation, it exposes the company to liability. So let's just get that first in terms of if you conduct an investigation, what does it mean for the employer? A bad investigation, one that looks like a cover up, it can easily become evidence in a lawsuit. And when a bad investigation becomes evidence in a lawsuit, the employer has just increased their risk in terms of their liability. The Culp v. Peters is an example. That was a bad investigation. And a bad investigation is not going to benefit the company. So, if HR knows that there is someone that the company wants to protect, then they can do that by terminating the wrong person or conducting a investigation that is incomplete, but that all comes out when it's litigated. And one of the things you'll find is that sometimes employers, I'm not saying all the time, but sometimes they will take their chance. They will take their chance and they'll say, what are the odds? What does this mean? Well, that's fine. I don't care what it means. I want this person gone because of these other reasons that they want the person gone, or they don't want the person who is accused to be held accountable, and they have a reason for that. What does that mean? They may have in-house counsel, they may have a very trained HR department that is explaining to them what it means, but they take their chances, they take the risk. We can't afford to lose this person. It just depends on the players and what is happening. Why is it that one employee, perhaps they don't want to see impacted by this allegation that's being made against him or her? That's what you saw in the Culp v. Peters case. And then I also want to bring to your attention something I said earlier in the live, which is, as employees, we don't always know all of the details. There are times when people have not been terminated, when the prevailing thought in the workplace is that that person should be terminated, but there are extenuating circumstances that do not warrant a termination. Um, and so you don't always know the facts of everything that is happening. Now, if you know the facts, as I said earlier, if you have both employee files in front of you, you know what they're accused of. You mentioned the word pretext, right? So you feel like whatever's happening is not the real reason for the course of action that's being taken. You feel like there's another reason. You may feel that way. What evidence do you have that points to that? And again, it is true. Sometimes employers will roll the dice and just take the risk. It's not uncommon for that to happen. And sometimes they say, well, what's the worst that can happen? Sometimes the worst that can happen is pretty bad. And sometimes it's not. It's something that a price that they're willing to pay. They know that for an employee to find a lawyer who's willing to take the case, who's willing to fight as long as they have to fight in court. If you look at any of the cases on the channel, I think it's very obvious that none of these cases are decided overnight. A lot of these cases go on for years, and it takes conviction. It takes a lot to keep that fight going. And so, how many employees are willing to do that? Some of them aren't. Some of them may start out as though they're willing, but as it goes on and as it draws on, they feel like I'm just not going to fight anymore. So the employer is aware of all of these things, and they have resources, and they assess the risk, and they analyze what would they be looking at if they took this course of action or that course of action, whereas employees may not have those resources. You need to have a very good way of demonstrating and documenting what you have experienced, so that when it goes to trial, you can win, you can avoid summary judgment. A lot of times, if you avoid summary judgment, what I've seen and what I've shared with you through the cases the real stories on the channel is a lot of times if an employee survives summary judgment, then it's settlement discussion. Then it's time to let's talk settlement. We didn't win on summary judgment. We don't want to take this to trial. Let's see how we can resolve this without it becoming a big deal. And so, all right. So let's look at. Okay, so there's another comment here. I guess. I guess it matters if the illegal misconduct was by another employee versus by a supervisor or company leader. Yeah. I've heard maybe from one of your videos that a good investigation helps them avoid liability if the complaint against another employee, but not if the misconduct was by a supervisor or company leadership. If they acknowledge in their investigation that a supervisor did indeed engage in the illegal conduct, doesn't that make the employee's legal case much easier if the employee decides to sue? Not necessarily, because remember, if you if someone uh touches you in a way that they shouldn't, okay? There's a video that I covered on the channel where an employee was groped at work. The employer admitted that she was groped at work. She was terminated. She was terminated for poor performance. She took her employer to court and she said to them, "You terminated me because I reported that I was assaulted at work." And her employer was able to show it is true. You were insulted at work. We took your complaint seriously. This is all the things that we did after you told us that you were assaulted at work. So just because the employer conducts an investigation and acknowledges that there is wrongful conduct, it doesn't mean that they're going to be exposed to liability. Now, if you go back and look at it's nuanced because some of the states, so I've done some trainings. I think if you look at the harassment training that I did for California, I think California does have liability that is the threshold is lower, meaning someone who's groped at work, it could result in liability if it's the groping is done by a supervisor. So it is state specific. If you go back and look at some of the trainings for specific states that I've done on the channel, you'll learn a little bit more about instances where states might say, yeah, this one occasion means there's liability. But as I've just explained about the case that I covered on the channel where an employee was in fact touched at work, the employer acknowledged that she was touched at work, but took action so that it did not continue to happen, which is what they're obligated to do. They're obligated to show they took the complaint seriously and that they stopped it from happening again. There's another case that I covered where a supervisor, there were two pharmacy students, workers, employees, they worked at Rite Aid. One, both of them were married. One employee received lewd messages from her supervisor who worked with her at Rite Aid, and she reported it. And she said, "Look, he sent me these messages and it's inappropriate." They fired him. She took them to court. She didn't go back to work. She quit. She took them to court and the court said the employer took the right action here. The employer did what they were obligated to do. And there were some nuanced things in that particular case, in the Rite Aid case. But the point is if an employer admits that the employee's conduct is inappropriate, it doesn't automatically mean liability. Remember, what your employer is doing is they are not a courtroom. So you've got your culture, you've got your policy, and you've got your legal threshold to determine if something has happened that's inappropriate. The culture is all about what the employer wants the workplace to be. How do they want people to feel when they're at work? but the policy violation is something that HR is looking at. Has there been a policy violation here, and what steps do we need to take? There can, in fact, be a policy violation without an issue that is also illegal in the courtroom. You're not always the 2 don't always have to be, the same, and that's what some of the cases on the channel will show, that some of the policy violations that an employee experienced is not going to necessarily mean that there is illegal conduct that's happened at work. Okay. So, one of the things I wanted to mention to you all tonight is the video that I'm publishing on Sunday because it involves another investigation. It's one where an employee made a complaint. Okay. She voiced a complaint at work. The employer investigated the complaint, but the investigation itself was one of the employer's biggest problems in court. It was one of the things they could not shake, and the jury awarded the employee, in this case, $2 million in damages, which included punitive damages. And so, I want you to be sure to watch that case on Sunday because it's going to show how courts and juries will look closely at what the employer did, meaning who was interviewed, what evidence did they ignore, what evidence did they pay attention to, what questions were asked. And I think that it goes and fits very well with what we're talking about tonight. And you can go back and listen to any of the videos in the investigation playlist because it will definitely give you insight on investigation, the process. I think in one of those videos, I literally walk you through what you should expect when an investigation takes place at work. And I want to encourage you now to hit the like button. I see that we don't have very many likes. So if you could take a moment just to hit the like button for me, I would really appreciate that. Okay, so as I mentioned earlier, investigations are something that if you're not in HR, it's not something that you're going to be exposed to routinely. But if it happens to you, it is so important that you get the knowledge. Don't go into an investigation clueless about what to expect. Don't make an allegation clueless about how your employer should respond to your allegation. The more knowledge you have, the more information you have, the more confident you can be about what is going to happen. And that gives you a sense of, I mean, at the very least, it doesn't guarantee your outcome, but it certainly makes you feel a little bit more secure in what you're up against and what you're dealing with. All the cases, I think I've done hundreds of cases at this point on the channel. And one of the things that's important from the perspective of each employee, there's not an employee that said or demonstrated that they regret bringing their case to the courtroom or to HR. But there are many that regret how they did it. There are many that didn't know what steps they should take. There are many who didn't know when they should take a step. When is the right time to make a complaint? How do I make a complaint? And so the training, the resources on the channel, that's what it gives you. It gives you the information so that you can see how these things play out and you can have greater awareness around it when it happens to you. If you've been in the workplace for any period of time, none of the things that I'm talking with you about are going to be new. Everything that I'm sharing with you, you're probably somewhat familiar with it. The questions you're asking definitely indicate to me that a lot of these things aren't necessarily foreign to you is what I mean. But when it happens, if it hasn't happened to you yet, it's probably just a matter of time. Why? Because that's how things are at work. If it has happened to you, you know it's possible, and that's why you're here, and that's why it's important to get the information from the channel. So I'm going to check the chat again. I want to see if there are any other questions. Okay, and I see I am Batman here. Thank you so much for being here. Uh, I don't see any other questions. Um, Feel free to, I know some of you send me messages in email. Feel free to continue doing that. I know sometimes it's uncomfortable to talk about everything that is happening with you at work, and I understand that. If you want to make comments, I think it's a great opportunity for other people to learn from your experience and knowledge about what you've experienced. But if you're uncomfortable with that, I also encourage you to send me emails. I do respond to the emails that I get as well. Okay. And I see someone says, I have a question. Okay. What is your question? I am here to help if I can. My supervisor recently preemptively took a strike against me, and I am oh, you're doing an investigation for her from HR. Okay, so it sounds like you have made a complaint against your supervisor, because your supervisor, did something, took a strike. I imagine that is with your what your supervisor didn't feel like you were doing something right. Does that mean take a strike against you? Um you said your supervisor preemptively took a strike against you. I don't know what strike means, if that possibly means that your supervisor did something that you don't think is right and you made a complaint. I think that if you are going to make a complaint in HR and it's about performance, I do have a workbook on the channel called uh, How to Report, How to Report a Complaint to HR, and the reason for that is you need to make sure that you are sharing things in a way that HR understands the seriousness. If it gives the impression that you are in an argument with your supervisor, that may not be taken as seriously. But if your approach is more about how your supervisor is treating you differently and why they're treating you differently and the documentation that you have to support that, then that's a different conversation that you can have with HR. Okay. Unfortunately, disability discrimination, harassment, and retaliation. Okay. So it sounds like you're saying that this has to do with a disability that you have and that you are being discriminated against due to your disability. And it also sounds like you are experiencing disparate treatment. Disparate treatment is interesting because recently they've filed some complaints or made it so that disparate treatment, it's still on the books, it's still a law, but they're not pursuing it. The EEOC isn't pursuing it under direction that it's not. Uh, it's reverse discrimination, I guess is what you could say. But what I would encourage you to do is look at some of the cases that I've covered on the Americans with Disability Act. I think that's a great resource. Anytime you're talking about disability specifically, because there are specific procedures and steps that an employer needs to go through, and it's very nuanced. I talk about that in great detail in the disability playlist. So I encourage you to listen to that and to see what if you can identify any consistencies with your own experience, and at the very least, it will give you the knowledge about how the ADA would play out in court and how HR departments assess these issues when they're brought. Different HR departments assess these issues when they're brought by an employee. Yes, thank you. There is not emotional language, but should I include case law violations? It's an ADA FMLA disparate treatment. Yeah. So remember, you when you're at work, it's not illegal. You're dealing with a policy violation. If you want to talk about legal issues, that's what a court decides. A court decides whether or not your experience reaches a level that is a violation of the law. So, what I would have suggest to you is to get out your employee handbook. I would encourage you to look at what your policies say about how things are to be handled related to disability. The reason I talk about the cases all start with employees. They all start with employees who have concerns that they bring to their employer. Sometimes the employer doesn't react in a way that allows an employee to feel like what we talked about with Baldwin tonight. It didn't allow her to feel as though her allegations were taken and the right outcome resulted. And so as a result of that, um, she decided to pursue it legally. And that's where it goes to the courtroom and you're talking about case law and precedent and those kinds of things. When you're in the workplace, you wanna look at your employment policies. That's what you wanna focus on. Don't go into your HR department talking about case law. And again, if you look at the workbook I have, it walks you through what that process should look like for you. It talks to you about what policies you have and how to apply those policies to your circumstances and what language you can use to help convey the seriousness of your allegation. That's at work. If you're going to see a lawyer, similarly, you want to make sure that you have a timeline, that you have facts that can support whatever your allegations are, and of course, that you have evidence. But there's a very different analysis that is applied in a courtroom and to legal issues than what's applied when you are dealing with an allegation that you're making at work. And I definitely don't see value in citing case law to an HR department. An HR department is not they're not a legal department, they're not a courtroom, and their job is to assess your complaint against their policies. So someone says they what changes when a large corporation outsources HR and management is the investigator? Management is the investigator? Okay. So investigations should be done by an objective, neutral party. Look at the investigation playlist. It talks about who is the right person to conduct an investigation. I did a video. I published a video last week on the NFL, and that video was actually about arbitration and how a employee raised a complaint about retaliation, discrimination and retaliation, and the arbitrator was the NFL commissioner. And the court said, "Nah, that's not going to work. We're not going to allow the person who is the claim is being made against the NFL, and the NFL is actually going to arbitrate a complaint that's made against it." So I bring up that case, and if you haven't watched that one, that's a very good one because it talks about arbitration, and there's a arbitration playlist if you're dealing with something like that. But My point is that you need someone who's objective. You need someone who can demonstrate that they don't have bias. And that doesn't mean that the person has to be completely uh unfamiliar with the employer, but it should not be the supervisor who's doing the investigation. Again, when the investigation is not done the right way, the investigation itself can become evidence against the employer to increase the employer's liability. I think you have seen that in the cases we've covered. Okay, so one on ones, and they picked HR as my neutral party. They are the same people who covered everything up. So HR covered everything up. If HR covered everything up and HR's doing the investigation, sometimes, and this is where your handbook comes becomes so important. It's important to get out your handbook and to take a look at what your handbook says about your outcome and what you have in terms of a right to an appeal. Sometimes corporations have so many layers that they give you the right to appeal something several times. And if you're dealing with something like that, if you're dealing with something like that where you feel as though you haven't been treated fairly, look at your handbook and see if you have the option for an appeal. If you don't have an option for an appeal, I've covered several cases on the channel where employees continue to work for an employer and they decide to pursue their claim through either the EEOC, or they might move forward with a complaint, even beyond the EEOC, if they feel like it's warranted. So, um, an appeal, if you don't feel like it's right, see if there's a policy around that. And even if there isn't a policy, you might have someone you can appeal to. But it's important to know your culture. It's important to know the environment that you're in so that you can make a decision around what is the best course of action. So those are some of the ways that you might want to pursue justice for your, for what you're experiencing there at work. I'm at an all-time low as this situation is making my PTSD symptoms worse. I have an attorney, but would like to hear your opinion. We will likely sue. The investigation is ongoing, but yet I still need to interact with a manager who is performative in front of HR. Oh, wow. Oh, wow. So, I don't know what your circumstances are, but I just wanna speak generally. When a employee accuses another employee of something inappropriate at work or something that is creating an environment for them that makes it difficult for them to work in, one of the things that HR can do is they can separate the employees, even if it's temporarily. And if HR isn't volunteering to do that, I would certainly request it. I would request it in writing, and I would request why in writing, because that also becomes part of the story that you will share in court, that you made your employer aware of this, that you had these experiences. And unfortunately, despite making your employer aware, there was no action taken. And if you look at the disability playlist that I have on the channel, you're going to see several instances where employers did delay a request for an accommodation specifically due to a mental health issue. And the courts have been clear about what the standard is there. So I would encourage you to look at some of those videos on the channel to see how the court assessed an employee's request for an accommodation due to a condition they were having that was either exasperated by the work conditions or caused by the work conditions, and see how the court responded when the employer did not give con- uh, serious concern to the employee's request, especially a well documented condition. So that's something that you can go back and review on the channel to understand how that is perceived. And if nothing else, part of what I do is giving you information so that you can know if what your concerns are if they can be legitimized through a formal proceeding. Because a lot of times people have concerns and they're like, okay, well, is this legitimate? Is this something that is real? Is this something that I am making too much out of this? And so what the videos that I publish on the channel do is they demonstrate to you how other employees who have had similar experiences have gone through the process of making a complaint and then pursuing it legally to know whether or not what's happening to you is valid, or if it's just some uh, you know not just some thought that you're having, 'cause, it's unfortunate, but a lot of good people at work, they question themselves. They question the reality. They feel like they're making a big deal out of what they are experiencing, and it's not until you see a common thread among employees that you feel confident in what your own concerns are. And so go back and listen to some of those videos, specifically the ones on disability, to help you gain insight on what happens when an employee raises a complaint and it's dismissed by the employer. I complained 8 times. He's my manager. Yeah, and I mentioned earlier Annie Shaparian, she complained more than a dozen times, and her employer continued to ignore her complaints. There was another, video that I did about an employee who had an allergy at work. It was a seafood allergy, and she complained several times. All employers are not going to do what they need to when it comes to a complaint that's made by an employee. That's the reality. That's one of the reasons why it's important to know what your options are, and it's important to understand whether or not your rights are being violated. Okay, another question here. Why my previous employer offered me $5,000 to sign waivers of suing them while they terminated me for misconduct. They never included in my termination letter. So I don't know if you signed that letter for $5,000. Uh, I don't mean to laugh, but that's $5,000 to sign your rights away. $5,000 is not a lot. Okay, so, um, that happens though. That, they'll give you something in exchange for signing this waiver. I did I published a video maybe a year or so ago about severance agreements, and that's where those waivers are actually found, in those severance agreements where people waive their rights to sue their employer. If you haven't watched that video and you've been asked to sign a waiver of your rights, I encourage you to watch that, because sometimes even if you sign, there might be a way that you can still uh, pursue litigation even if you sign. But I don't know your specific situation, but again, watch that video that I published specifically about severance agreements because I do think that it's eye opening because of the recent changes that the NLRB has made related to if severance agreements are legitimate. Do you remember specifically which video you're referring to, delaying the accommodation for a mental health condition? It's called Delay Equals Denial. I believe that's the name of it, but it's in the accommodation uh, ADA playlist. And it's called Delay Equals Denial. I'm pretty sure that's the name of it. Quiet firing. Thank you. You're awesome. My supervisor is actively gaslighting and coercive control in the workplace, destabilizing. Yeah. And the best I can tell you about experiencing things at work, because they are so unnerving. And if you dealing with PTSD, as someone has already mentioned, or if you have personal circumstances at home that make it difficult to add this additional layer on top of everything else you're going through and dealing with, uh, I encourage you to. I know you said you sought an attorney, which is great, but I encourage you to document your experience. That is so important because sometimes showing what you're experiencing after you make that complaint is important. Okay, sorry about that. Let's see. There are any other comments here? Okay, I don't see anything else. But what I was referring to earlier is documenting what you're experiencing because sometimes people feel like, well, nothing is going to come of this. They're just going to cover it up. They're not going to, it's not going to be fair for me what happens. And that may or may not be true. There's no way to guarantee your outcome. People go to court every day and don't get the outcome they want. People go to HR every day. I mean, I'm sure when Susan Baldwin went to Blue Cross Blue Shield and she had 5 pages of evidence demonstrating how her supervisor had been harassing her and many of the things that he even admitted to, or if you look at some of the other cases I've covered on the channel where an employer looked into it or didn't look into it and the employee didn't feel like the outcome they received was the right one, that is understandable because there are no guarantees. But I also want to make you be aware of the consequence of the mental toll that you need to take care of yourself the best way you can as you're going through this, because it's serious. It affects people in ways that sometimes you can't qualify. I mean, even I covered a case on Bojangles a few months ago where an employee was openly harassed. She knew she was being harassed. Bojangles knew she was being harassed. She got $20,000. $20,000 is a penance for what she had to endure. And so the mental toll that something takes on you, that documentation helps you that way as well. Even if it doesn't give you the outcome, and I hope it does, I hope for everyone to get justice. But if you look at the cases on the channel, you can see that that doesn't always happen. And I'll tell you, it starts at the very beginning, how you complain before you report. That's one of the workbooks I've published for that exact reason, to make sure that you do it the right way. You at least want to be somewhat informed before you raise that complaint. Document what's happening so that you can verify and validate it for yourself if for no one else, as we are having these experiences, they need to be validated. Don't look at it as, oh, I just have to win in court. Yes, you should win in court if justice hasn't been served at work. HR should do the right thing. But what about you? What about what's happening to you while you're pursuing justice? What about what you have to endure as you're trying to figure out the right thing to do? How are you caring for yourself? Don't forget about that. That is really important. And I think a lot of people put that on the back burner. They think I need to document for all these other reasons. We have to be sure that we are giving time and attention to ourselves when we're enduring the valleys of life at work. Sometimes things are great and then sometimes things are low. And either way, it's important to make sure that you are taking care of you. There's another comment. I'm still wondering, sorry to beat a dead horse, but if state law means that an employer will have liability for something illegal by company leadership, regardless of how they conduct their investigation, doesn't that mean if they acknowledge the allegation to be true, that would make a lawsuit by the employee, if the employee pursues a lawsuit, easier to prove liability? And so they have an incentive to not admit something if the allegation is from company leadership. So it doesn't automatically mean if I acknowledge, let's look at the case that I covered on the channel where employees have acknowledged that, or an employer has acknowledged that there's been wrongdoing. In those cases, the employer still won, even when they acknowledged wrongdoing. The reason they won is because they demonstrated that they, and I'm generalizing here, but you go back and look at the cases specifically, but in general, they were able to demonstrate that they took the complaint seriously and they did a thorough investigation related to the complaint made by the employee, meaning they looked at evidence, they were able to demonstrate that they interviewed witnesses. So, an admission of a violation does not automatically give incentive for an employer to not be truthful. It doesn't, because if an employer acknowledges that a violation occurred, that someone did something that they shouldn't have done, and the employer says, "Yes, it's true. This employee X did do something inappropriate to employee Y." They say, "Yes, that happened." Just because they say yes, it doesn't mean that they're going to have liability. Sometimes it means that they don't have liability or they have less liability. It's remedial action. It's what steps did the employer take once they knew about it. That's when that liability line is drawn. That's where it's drawn. Once we knew about it, what did we do? Remember the fossil case I mentioned to you? She had evidence that she was being harassed. The employer acknowledged that she was being harassed. The employer terminated the employee who was harassing the employee who made the allegation of harassment. They terminated that supervisor who was harassing her. Okay. But what happened is when she went to court, the court said, well, the employer did all the right things here. Once they knew about it, they did something about it. And that's why it's okay for an employer to admit that someone has violated policy. The line isn't in preventing people from doing bad things. The line is when you knew people were doing bad things, what did you do about it? And what have you done even prior to that time? For example, have employees done training? Have they done the harassment training? It's amazing to me how many employees have not gone through harassment training. That's one of the reasons why I include training on the channel. You take the training, you take the quiz, you get the certificate, you know whether or not you understand what harassment is and what it means to violate your rights. Employers are supposed to do that. If they don't, and you're not aware of what your rights are, then that creates liability for your employer. But the liability isn't there just because the employer admits that someone violated policy, that someone harassed someone else, or that someone was stealing, or whatever the issue is. That's not where the liability is created. I hope that answers the question because I know you had that question before the live started and you've asked it again. So I want to make sure that you're walking away from this live and you're understanding that it's okay for an employer to admit that an employee did something wrong. Now, when I talked tonight about Culp v. Peters, what happened in that case was they did not believe Culp v. Peters. They wanted to protect the person that Culp v. Peters was accusing. So that is a possibility. That kind of thing does happen, but it's not just because they don't want to admit someone did something wrong because they think there's liability there. That's not where that's not where the employer is going to be held accountable. The employer is going to be held accountable in ways related to what they did or didn't do when the employee made the complaint. Okay, I understand that an admission does not create liability under federal law, but it was my understanding that under certain state laws, then the investigation does not remove liability. The problem was done by the problem was done by company leadership. So I understand there are cases where the employer did not have liability even though they admitted. But I'm asking about specific state laws where a good investigation does not remove liability? Yes, that's a great question. Okay. And so, in those instances where it does not remove liability, one of the things to remember is that an employer who reaches the wrong outcome despite evidence, when they go to court, they are going to have to defend that. And if they can't, they have increased their liability even greater. So, in those states that you're referring to, and I've done some harassment training on some of those states. I know which ones you're referring to. So, in those states where there's automatic uh, liability because the supervisor did it, and that's it's black and white. If you did it, then there's accountability, there's liability, and if you didn't do it, there's no accountability, there's no liability. So let's say if the employer knows if we admit this, then now that supervisor is going to cost us X number of dollars. If they don't admit it and then it's pursued legally, their liability is going to be even greater. It's very difficult to defend the wrong outcome when you have so much evidence to support that the what the right outcome was. Ani Shaparian is a perfect example of that because they continued to say to her when she made complaint after complaint that her complaints were not valid and that there was nothing for them to basically investigate. And that's why there was so many fines and penalties. And she was actually in one of those states where that automatic liability, is a problem or is created by a supervisor's conduct. She was actually in one of those states. And what happened was when the employer went to court, I think the payout for her for that case was over $160 million. So it doesn't benefit the employer. Will they do it? Might they do it? Absolutely. That's exactly what they did in Annie Shaparian's case. They denied that she had any kind of a claim, a legitimate concern. They denied her allegations were legitimate. So the court said, because she had these concerns, you didn't take them seriously and you didn't admit to them, we're going to force you to pay even more than what you would pay otherwise. And there's a lot more to that case, but that was definitely a part of it. But I'm asking about, okay, so the next thing. I was fired from a job after I submitted a formal complaint about a negative change in behavior coming from my supervisor after I requested an accommodation and submitted supporting documentation. I submitted the written complaint to our in house counsel. Oh, they held a shoddy investigation and fired me immediately. I did file a lawsuit, and they later said they were investigating complaints against me. I was not notified of that. I don't think they were investigating me for complaints about me. They were deflecting too much detail to go in here, but I work in HR and I lost all faith in my career. Now I'm trying to figure out how to get out of HR. Okay. So, when I cover cases on the channel, one of the things I do is I cover defenses. I cover how did the employer defend itself against these allegations? And I have to tell you that sometimes they twist things and turn it all around and upside down. Yeah, they do that. If you don't think that can happen, you might be a bit unaware of what it means when you go to trial or you pursue something legally, but they're going to look at whatever way they can. And the only thing that's going to overcome that kind of I don't want to say attack, but I want to say the only thing that's going to overcome that position that they take is your evidence and how your attorney is able to convey that to the court. But yeah, employers, when they go to court, they're going to look to get this thrown out on summary judgment. They're going to look to have resolution. And court is not about who's right or wrong. It's about what is able to be proven under the law. And that's where a lot of employees lose faith because they have been treated unfairly and they know they've been treated unfairly and they feel as though the employer should be held accountable for it, but they are not sure about how to make that happen. And when you go to court, the case I covered recently with the NFL, they appealed to the United States Supreme Court because they wanted their arbitration agreement to be effective. If you look at that case, the employee in that case, he signed his arbitration agreement when he wasn't working for the team that he accused of retaliation, but they still wanted that arbitration agreement, the NFL did, to be held as a legitimate reason to keep his claim out of court. Now, is that right? When the complaint that he's making wasn't related to the arbitration agreement he signed, meaning he was working with a different team when he signed the arbitration agreement? Is that the right thing to do if this person was not treated right? He felt like he was discriminated against, he was retaliated against. I mean, you this is what happens when you go to trial. It is not, "Oh, well, they did the wrong thing by me, so I deserve to be compensated." No, you have to have strategy. You have to have evidence. Yeah, you may have been treated poorly, but that's not the one thing you should see in the cases that I cover on the channel is a legitimate concern that's brought to an employer's attention, and an employer deciding how they're going to deal with it from the point of complaint all the way through to the courtroom. And if you listen to the cases on the channel, videos I've published, you can see that some employers go to the extreme at every step of the way. And the penalties they face may be great. And then some employees are vindicated. Sometimes it takes years for them to be vindicated. Um, the safety cases that I've covered on the channel certainly come to mind where an employee says, "There's a hazard concern with me being in the workplace under these conditions. This is a hazard to me and it's a hazard to other people." And the employer ignores it, or the employer gives it no attention or no serious attention. And from that moment all the way up until they go to court, that sets the tone for what it's going to be like. And it's not a walk in the park. That's why I always say, sometimes you have to decide, do I want to stay here? And there's lots of reasons to stay with your employer. And there are lots of reasons that you don't want to stay with them as well. It just depends on you and your personal circumstances. But it's not an easy thing to get through to pursue something legally. That doesn't mean it shouldn't be done. I have a playlist called When Employees Win. Look at that, listen to that playlist and see all of the instances where employees were able to prevail. The common theme there is despite how the employer responded and defended itself, responded to the original complaint and defended itself in court, despite that, the employee was still able to win because they had evidence. They had facts to support their position. Okay, someone else says, "Thank you so much for the helpful explanation. I just wanted to understand what their motivation could be. And it sounds like the specific state law is a key distinction." Absolutely. The specific state that something happens in, it makes all the difference. That's why I have trainings on Illinois, California. I have a federal training which covers just federal harassment in general, but I started going through state by state as much as I can, and I'm still building out that library regarding the specific laws related to the complaint where you make the state where you make your complaint. And then there are some employees who work remotely and they'll try to pull from different laws in multiple states. And so that gets very confusing as well. But understanding your state law is really important. And I can tell by the fact that you asked that question and you asked it more than once. You asked it at the beginning of the live, you came back and asked it again. I can tell that you're someone who's really thought this through. And I applaud you for doing that. I think more people should think through what this means and stop believing that you're going to go in, you're going to make a complaint, there's going to be an investigation, and the outcome is going to be what you want. It might be, and it may not be. You need to have a strategy. You need to have a plan. You need to know what you're going to do if the outcome is not what you want it to be. And you also need to know what you're going to do if the outcome is. Because just because the outcome is what you want it to be doesn't mean that you can't have issues in the future either. Someone else says, "My former employer filed a weak motion to dismiss, but the facts I submitted shattered their arguments. That's it. That's it. Right there. That's what it takes. Your evidence, your timeline, your documentation, the information that you have. That's what's going to make a difference, not the fact that you weren't treated fairly. You may not have been treated fairly, but that's not what's going to win your case. And it's also not what's going to make a difference if you I mean, when you go into HR, it does depend on HR. I know some HR departments may look for objective ways to make things as manageable as possible. And then some HR departments might be dismissive of legitimate complaints, which is always problematic because we know how much work affects our lives. We know how much time we spend at work. We know the impact it has on us when things aren't going well at work. And so it's mind boggling to me how you could have an HR department. But, there's a case I did on the channel a while back regarding Patricia Oliveri was the employee's name, and her HR department, according to the case records, her HR department basically turned against her and tried to side with the employer every step of the way. So it just depends on the HR department and who you have, but you need to be strategic and you need to be ready for what varying outcomes there are. And for the person who said that she's was in HR, she's no longer interested in being HR. I understand that. Sometimes we need to change and make a new path for ourselves because our experience has been so it's been so negative that we feel like staying with an employer would make it difficult for us to function and to thrive. And I respect that, even if it's the profession. But I would just encourage you to sometimes things are lessons that we have to learn for whatever reason that opens our eyes to see the reality of what it means when you make a complaint, even if you're in HR. Even if you are in HR, it does not mean that you are safe from retaliation and discrimination. Uh, about a year ago, I did a case on the channel where two lawyers and I've done cases where very high functioning leaders. Anish Shaparian was a professional where they're high functioning professionals, but they're still targeted. And two lawyers were targeted. They ended up winning the case. But if it can happen to them, it can happen to HR leaders. It can happen to anybody. No one is immune. If you look at the cases I've covered in the channel, I've covered the gamut of professions. I've covered everything from a person who is the person who cleans the janitorial service all the way up to a key leader in a large corporation. No one is immune from retaliation and discrimination that can happen at work. So look at it, consider it as a learning lesson rather than removing you completely from the profession because you might be an advocate in an organization that needs an advocate to do the right thing by people. We need more leaders like that who are willing to pursue justice for an employee while they are still employed rather than, taking it to the courtroom. Someone else says, my HRBP is a defense attorney. So you can imagine how I treated, I think how I was treated during the investigation. She tried several times to trick me. Do you think putting all of my Okay, wait a minute. She tries several times to trick me. Okay, so I want to that's one of the things. Look at the investigation playlist. One of the things I covered in the investigation playlist is the way that an investigation should be conducted. And I think sometimes as employees, we assume that we don't have rights. We assume that we don't have the autonomy to do anything differently. And it's okay to say, to whoever's doing the investigation, to ask them if there's someone else who could conduct the investigation because you don't feel like this person is being objective or um, what I'm saying is I'm not telling you what to do, but sometimes we need to consider what our options are and consider whether or not the person we're working with who is investigating our legitimate complaint is the right person to do it. And if that person is not handling it the way that it should be, and you can't get anyone else to do the investigation, that's something that you need to document. That investigation becomes another part of how your complaint was not handled the right way. Okay, there's another comment here. I asked for the investigation files and she declined. Interesting. So, when you're talking about an investigation, what an employer, if you listen to the investigation playlist, one of the things I cover in that playlist is what you are supposed to get at the end of the investigation. I talk about how the investigation should be conducted, and I also talk about what you should expect. And if you're not getting what you should at the end of the investigation, I talk about how to handle that. I talk about the importance of requesting that document and making sure that you are memorializing what the response was. So if you requested the files, I will acknowledge that. Again, that's something that would probably come during discovery later on if you were to pursue it legally. But I also think that there's a real opportunity whenever you're going through an investigation and you're not given anything. You're not getting anything to help you understand what just happened. Remember, an investigation is something that is a very daunting experience. If you've ever been through it, it's one of those things that, you just want it to be over as soon as it possibly can be. It doesn't make you feel great to have that, to endure that. So you go through all of that, and at the very end, you don't receive anything that is adequate in terms of communicating to you what the outcome is. That's a problem, and you should request that, and you should document if that wasn't given to you. Okay. Well, I think that is, let's see, there's another comment here. Ohio is one party state. So I went in with my audio recorder. So during discovery, they will have to bring it out and we will compare with my audio recording. So, does your employer have a policy regarding recording? Um, some employers do, and some employers don't. And yeah, that's something that I would definitely turn over to my counsel so that they can see what happened. And they will know whether or not the outcome is substantiated by what you said and what was uh, talked about during that interview with that attorney. I don't it's interesting when you say the HRBP was also an attorney, because when you're doing an investigation, you shouldn't be under, you shouldn't be on the witness stand. I mean, it's a conversation, there are questions, but it's not that aggressive. That, you know, being in a courtroom is totally different than having a conversation at work about what happened, where you're seeking information so that you can know what the best course of action is for the employer and also for the employee who's making the complaint. Okay, someone else said I'm pro se. It was really aggressive, yeah. Yeah. And so if you're pro se, you can file a lot of motions, and things like that. I would encourage you to talk with a counsel, even if you're pro se. Sometimes they will give you an hour or 2 of their time, depending on the counsel. If they're, a senior person, you're probably looking at $500 to $750 for an hour. If they're not, you might be looking at $250 to $300. But either way, it's important to get counsel. I will tell you, being in a courtroom, being able to argue your case is definitely an art. But even beyond that, you need to know how to do things procedurally. And a lot of new attorneys don't know how to do things procedurally. I am not a litigator, I work in a corporation. So if you were to tell me to go into a courtroom and to argue something, I could do that all day. I'm very effective at it. But if you were to tell me to file a complaint procedurally and make sure that it's right and I would have to research that and that would take me time. And I wouldn't even after I researched it, I would have to probably doubly research it again and then talk to someone who's more senior in terms of litigating to make sure that I haven't missed anything because when you get to court, if you've missed anything procedurally, you can easily get things thrown out. I did a case maybe 6 months ago or so about an employee who represented herself pro se, and she had actually gone through some pretty big hurdles to get her case in court, but her claim was ultimately thrown out for a procedural reason. So that those procedures are very, very important. And I am here to tell you that those judges are not going to make arguments for you. They will give you a little bit of leniency if you're pro se, but it certainly isn't going to go far enough to carry your case. So just be aware of that. I requested their position statement from the OCRC and it was contrary to everything that happened. Oh, wow. Thanks. I will. Thanks for the heads up. Absolutely. Yeah. Okay. Okay, well, listen, we have been on here for a while. I enjoy spending this time with my viewers because you all, the only time we really have a chance to interact is during the lives. I try to do one at least once a month. Otherwise, I'm just publishing videos, and I know you can tell I do a lot of research on the videos before they're published, and I try to make sure that I'm as accurate as possible. I do use a script to make sure that I don't miss anything. But on the lives, one of the reasons why I love them so much is because it's just an opportunity for us to have free flow of conversation. You can talk about what you're experiencing. I can tell you about what videos might be applicable to your experience. And I think that really goes a long way to building our community that we have here. So thank you so much for your time tonight. The video will be live if you want to come back and listen later. And I'll see you all next month. Thanks so much. Take care now.